call 2014-284, State of Arkansas versus Amos Joseph Duquette. Mr. Duquette was ordered to reappear here today for attorney status after his appearance in front of Judge Putman on December 4th. At that time, he entered a plea of not guilty at arraignment and was set down to reappear here today. I'd made the appointment of the Public Defender's Office, so the attorney status issue is resolved. Court is going to set this matter by scheduling order and set him down for trial the week of June 22nd of 2015. His pretrial hearings will be set for May 7th of 2015, and his reappearance date is set at March 12th of 2015. That's the next date you'll be required to be in court. Anything further to come before the court?
No, Your Honor, there's not today.
All right, you may be excused, sir. We have 2013-319, State of Arkansas versus Donald Dragers. Mr. Dragers appeared before the court on November 20th, entered a plea of not true on these matters, and they were set down for hearing today. Is this matter for hearing today?
No, Judge, it's going to be for some sort of a plea. It'll be resolved today. Give us just a minute if you don't mind, Your Honor.
All right.
Why don't you bring it back? Let's talk about this a little bit, Your Honor.
All right. Put that in the to be recalled stack for today. 2012-52, State of Arkansas versus Ron Culver. Culver appeared in front of Judge Putman on November 13th, entered a plea of not true, and the matter was set over to November 20th, which date he appeared before this court on the petition to revoke, and the court set this matter down for revocation hearing on today's date. Once again, the court inquires, is this matter for revocation? Hearing today?
No, Your Honor, it's not going to be for hearing. I've talked to Mr. Culver, and it's a situation that will resolve by some sort of plea, Judge.
Okay. So we recall it today, or does it, and the 60-day requirement's already been waived, do we need to set it off till January?
You know, probably the safe thing to do would be set it off until January, and then if Mr. Kincaid makes and TJ makes a plea offer, we can always bring him back at 1.
All right. Very well. Pardon me?
Can I say, actually, I was not ever brought in front of the courts before the 60-day deal. November 13th, I was arrested on September 2nd. And that's kind of, and I'm just curious because I don't know understand what that implies when I have 60 days to be brought in front of the courts. I was arrested on September 2nd, and my first court appearance was November 13th.
Well, that's a matter you're going to need to take up with your attorney.
Okay.
And you say you were arrested on September 2nd?
Yes, Your Honor.
The warrant on the bond revocation wasn't even issued until
September the 4th. Yes, Your Honor.
Judge, he was arrested on a traffic stop and was arrested on criminal charges, how he came in my possession. So he's got other criminal matters pending, probably missed him. I don't know.
All right. Well, that's what I was guessing because of the arrest was 2 days before the warrant was even issued on the revocation, so that wasn't what he was arrested on. What the court was saying is if he's claiming that the 60-day requirement for a hearing has already been passed before he even appeared in front of Judge Putman, then that's something that we'll just his attorney will have to look into, and we'll, whatever the record shows will be the law will be applied. So that's where we stand right now.
All right.
If you'd look into that, I would appreciate it.
I will, Judge.
All right. This is 2008-44, State of Arkansas versus Jonathan Evans.
Your Honor, yeah, they violated my probation or my parole in Greene County. They gave me a 6-month violation. I didn't make my payments like I was supposed to, Your Honor, and I plead guilty for not making my payments, not showing up for court, Your Honor. But there's nothing I can really do now until I get back out in 6 months, back in
Your Honor,
in May.
I'm gonna stop him and,
Okay.
at this point, and if we could just take like a couple of minutes, let me visit with Mr. Nissel and Mr. Kincaid. And we
Yes.
can do something that will run concurrent with what's happening over in Greene
It runs
County.
concurrent as a matter of law, unfortunately. I reckon that this court sends him 89 days jail, we send him back to the jail. Prison wants him, we'll send him to the prison, he'll do the rest of the 89 days over there. That's what I recommend.
I'm waiting to go back to Greene County now. I've got other court state there. I've got
That's irrelevant. I'm just trying to give you your time here that you need to do.
yes, sir.
And
Well, Mr. Cooper, you take an opportunity to discuss this with
Let me-
Mr. Evans, and if we've got an agreement, we've got an agreement. If we don't, we'll handle it accordingly. Mr. Evans, you understand the agreement then that's
Yes, sir.
been reached here between your attorney and the attorney for the state?
Yes, sir. Yes, sir.
And by your previous statements, I understand you're willing to admit that you are in fact in contempt of the court's order with regard to requiring you to make certain payments.
Yes, sir.
In this matter.
Yes, sir.
So I'm going to treat this as a plea of true to contempt. The allegations contained in the petition will be reflected as a petition for contempt. The record should reflect that Mr. Evans is pleading true. Is that correct?
Yes, sir.
And that you're entering this plea of true freely and voluntarily?
Yes, sir.
Nobody's forced you into it?
No, sir.
You're entering this plea of true with an understanding that by pleading true, you're giving up your right to a hearing on the petition. Is
Yes,
that
sir.
correct?
Yes, sir.
In this case, you don't have a right to a jury trial, but you do, by pleading true, you are giving up your right to a hearing. At that hearing, the state would have the burden of proving that you in fact had violated the terms or violated the court's order.
Yes, sir.
And at that hearing, you'd be entitled to have an attorney represent you and assist you in defending yourself. At that hearing, you'd be entitled to confront the witnesses that appeared and testified against you, and after that hearing, you'd be entitled to appeal. All of those are rights that you're giving up by pleading true here today. Do you understand that?
Yes, sir. Yes,
And
sir.
understanding that, are you still willing to plead true?
Yes, sir.
Are pleading true? Well, you've already asked you if you've done that freely and voluntarily. You are here today admitting that you haven't made the payments that you were obligated to make by your previous judgment against you. Is that correct?
Yes,
The
sir.
orders
I
of
did
the
not
court?
pay them like I was supposed to. I
All right.
apologize.
Based on that, the court will accept the plea, find the defendant to be in violation of the court's order, and find him in contempt of court. On the contempt of court, the court is assessing 89 days in the county jail, and will direct him to, he'll be given credit for any time already served, and he'll start serving the 89 days here. The court is willing to run that concurrent with any sentences in other jurisdictions, but it will be, I can't order those other jurisdictions to come get you and take you there, but I'm going to assume they're going to.
Yeah, I guess whenever I left Greene County, the Greene County told the officer that was coming to get me that they needed me back because I have other court dates there. I'm still an inmate underneath their dockets and everything else.
Very well.
So-
All right.
All right,
So
so
I'm remanding you into the custody of the sheriffs here to wait transportation to those other jurisdictions.
okay. Thank you, sir.
All right, you may be excused.